Hi, I'm Jim Dodson. I want to talk to you about the situations where someone is injured because they step in a hole or there's some other kind of defect with property. Kind of a common occurrence would be a broken sidewalk or something that's been washed out or rutted so that it's dangerous for someone to walk across it. You know, people get injured every day on those kinds of situations. And typically, when you argue that type of case to the defense, their response will be that it's an open and obvious condition. You know, the implication being if the person had been looking more carefully, they would have avoided it. And a lot of times I've been told by clients when they first call the office that when they reported it maybe to an insurance company, that's what the response was. Hey, that was an open and obvious condition. You should have avoided walking in it. Well, it's true that the defense is always going to use the fact that something is evident, that if you had really been looking, you would have seen it. They're going to argue that that kind of reduces their liability or responsibility for the accident, but it doesn't make it go away. And the fact that a hole or another problem with a piece of property is kind of evident, that you could see it if you're looking carefully for it, doesn't relieve them of the responsibility to maintain their property in a reasonably safe fashion. So when you hear that term open and obvious, don't let it necessarily convince you that nothing can be done with your accident. The circumstances of every case are different, and I can tell you right away if it's something that we can help you with.